Yesterday, Dr. Miria Matembe appeared before Luzira Magistrate Court, where she was charged with one count of promoting sectarianism. She denied that charge and was remanded to Luzira government prison. On returning to court today, Miria Matembe applied for bail, arguing that she's of advanced age, has a constitutional right to bail, and is not likely to interfere with the ongoing investigations.
The charges against the applicant, they are not so grave in nature, and the charge is not among those that require exceptional circumstances, as is the case normally in the cases before High Court.
She presented for sureties including Lucy Akero, MP for Amuru District, Naomi Kabasherire, MP for Rushenyi County, Prima Kwagala, and lawyer Godibato Mushabe.
Your Honor, the accused person, former Minister of Ethics and Integrity, Constitutional Assembly delegate, and former member of Uganda Constitutional Commission. So, Your Honor, she makes this choice in itself underscores her commitment to justice.
The application was opposed by the prosecution, led by Miria Matembe, who argued that advanced age alone is not sufficient ground for granting bail.
We humbly pray that the applicant surrenders his passport to court. And we also pray for an order refraining the accused or the applicant from using such words the state may consider committing a crime.
She also argued that the presented sureties were not substantial because they are places of residence are far from the accused's home. The prosecution therefore asked court to deny the accused bail. After considering submissions from both sides, Magistrate Gloria Atim granted Matembe non-cash bail of 3 million Ugandan shillings non-cash, and the first sureties each 2 million non-cash.
I'm inclined to grant the bail application on the following conditions. 1. The applicant is to be bound in her own recognizance of 3 million Uganda shillings, not cash. Each of the 4 sureties is also bound in the sums of 2 million.
The magistrate, however, warned Matembe against making statements that rules out in the cancellation of her bail.
3. The applicant to execute a further bond of refraining from any acts of hostility or breach of peace till the case is heard and finalized. For failure to do so would lead to cancellation. The applicant will continue reporting to this court for mention pending the completion of inquiries and all during the period of hearing of the matter.
In her ruling, magistrate explained that bail was granted because the accused had presented substantial sureties and that there were no evidence that she's likely to interfere with the ongoing investigations. There was jubilation among Matembe's relatives, friends and supporters who had filled the court to capacity following the ruling. Matembe's legal team welcomed the court's ruling.
She's been very clear that she has been guided by the law, courage, compassion, and her belief as a religious person. And that is what should guide all judicial officers in similar matters. If that was to be the case, then the reason for bail would be resolved.
The people, the members of the public have been behind this, the Fourth Estate, the women who have also been here in solidarity, because this is basically the only way we can get our freedom.
Court will resume on 19th August 2026 for mention of the case. The offense of promoting sectarianism carries a maximum sentence of 5 years imprisonment. Upon conviction, Deborah Namamonde, UBC News.